Good afternoon, my lords.
Yeah.
I've addressed you on the first two grounds of our appeal concerning breach of Section 172 and 174, respectively. I'm now going to move on to deal with the grounds of appeal relating to relief. Now, those comprise grounds 3, which is split into sub 1, 3, sub 2, and then also grounds 6 and 4, and I'll explain how the different grounds of appeal fit together. Now, the judge held that there had been unfair prejudice. There's a clear finding to that effect. But he misdirected himself in relation to relief, and that led him to make an order that was, we say, fundamentally flawed. In particular, it did not amount to a fair and equitable remedy for the prejudice caused by Mr Costa's conduct. And just to recap on that relief...
Just to be clear, you say fair and equitable. I mean, they're nice words, but they're not in the statute. Do you just mean appropriate or proportionate or something like that? Because it's not. There's no equity here. This isn't a quasi-partnership. Why do you say? Why is fair?
Well, I'll take your lordship to the authorities which do use that formulation. It is, regardless of the precise formulation, I take your lordship's point that these are sort of broad words that one can substitute other equivalent words. The real point I would suggest is that it's a jurisdiction that gives the court a broad discretion as to what relief is required in order to provide a remedy for the unfair prejudice.
So do you have to show the judge approached that question of what remedy to give, either in a way that was wrong in principle or reached an irrational result?
So we say he misdirected himself in law in two specific respects, and we also say he exercises discretion incorrectly in respect of his decision on what remedy was to be.
Do you mean, I just need to tease this out for myself, generally if there's an exercise of discretion involved, the Court of Appeal doesn't interfere unless either there's some error of approach or principle, or the result is so far outside the range that no reasonable judge could have arrived at it. But just the mere fact that you might disagree with the judge and say,
yes,
well, another judge, he should have reached a different conclusion, doesn't get you home if it's a question of discretion.
My lord, that's why we take all of these grounds together. So where we say he's exercised his discretion incorrectly, that is in part because he's starting from the wrong position in law.
Okay.
So they run together to an extent. And just so we have firmly in mind the order that was made, it's at tab 12 of the core bundle, page 160. And your lordships will there see that he ordered that there be a further trial. This is paragraph 1 of the order, which he calls the quantum trial, to determine the highest value net of debt which a third party acting at arm's length would have attributed to the entire issued share capital. Then 2, that issue is to be determined at the quantum trial by reference to the findings made in the judgment and the parameters set out in the schedule. And then paragraph 3 is where he introduces this effectively a threshold. So the petitioner faces the burden effectively of establishing at the so-called quantum trial that the best price would have been in excess of $75 million. And I've taken you to this already, but it's just worth turning over the pages to page 165 and we see the parameters. But again, it's worth just recalling the words I just recited, which indicate that the parameters don't seem to be exclusive. The judge directed that the valuation quantum trial is to be on the basis of the findings in the judgment and these parameters. And I emphasised this morning the first 3 findings, which we say are significant, but there's a whole range of other parameters that you can see there. So, I mean, just to note, and I'll develop this in due course, this, whilst it's called a quantum trial, it's a rather different. The experts are being required to conduct a much more, at the very least, much more involved exercise than they would normally be expected to conduct in this kind of situation. Ordinarily, they would simply have the financial documents and be instructed to decide opine on the fair market value of the company between a willing buyer and a willing seller on a particular date. There might be a direction as to whether a discount should be applied. There might conceivably be specific directions as to adjustments to be made to the valuation. But what is envisaged?
I'm not sure that's right. On any valuation question, there are different ways of valuing the object. One may be a discounted cash flow of the type you've, I think, been describing. You look at the financials records and you take a multiplier and apply it to the last 3 years' maintainable earnings to arrive at a result. Other ways is if the market has been tested for a piece of property or a company, it's no different in principle.
My Lord, I wasn't seeking to distinguish.
You look at what offers evidence as to what offers might have been out there.
My Lord, I agree. But that's a question of methodology. And of course, one can look at the financial documents and apply some kind of metric or multiplier, or one can look at the market. And I entirely accept that.
Or both, because one provides a cross-check.
And you test, absolutely. But what the valuer is doing there is providing his opinion on the value of the company at a particular point in time, subject to any other very specific directions as to value. What this process envisages is the experts having purview over the entire sale process. They are supposed to be thinking about how Jeffreys would have conducted the due diligence. They are supposed to be thinking about how the company would have been responding in real time with regard to a CEO, for example. They have to take into account specifically the metric offers, but on the other hand, they also have to imagine that other offers might have been made. The company would have progressed contact with the Hut Group. In other words, this is a different kind of exercise. It's a much more involved exercise that the experts are being asked to deal with. And I'll come on to this, but I'm just flagging this as a point that I would suggest that not only is this entirely novel and unusual, what the judge envisages for this second trial, it's not really just a quantum trial. It's an examination of a process that the court says should have been undertaken by reference to some specific parameters, but one can only imagine a number of variables that one could think of as to what might or could or should have happened over that process, which the experts are going to have to be grappling with before they get to the process which normally happens, which Your Lordship just mentioned, of actually applying some figures and coming up with a number. So this is much more involved. It's very different from the normal idea of a quantum trial. So ultimately, though, as we see in the order, we have the threshold of $75 million and then 3.1 if that is if the petitioner is able to prove that would have been beaten in this particular counterfactual situation, they get a non-discounted buyout at 22.33% because that reflects effectively a sale of the entire company. If not, they get nothing, and they would just remain a shareholder. So the critical point here is that there is a significant conditionality applied, obviously, to the prospect of an exit through a buyout order.
It's really a causation trial, isn't it?
I beg your pardon?
It's really a trial of an issue of causation, which is identified.
It's an examination of the counterfactual.
Well, yes, but it's, you say that, I'm looking at paragraphs 55 and 56 of your skeleton, where you say the judge misunderstood your case on prejudice. The prejudice you say you suffered was the loss of opportunity to exit the company
Yes.
before 31st of December. And he's saying, well, it may be that even if Mr Costa had not failed to comply with or caused the company to breach paragraph 6.2, and in that event, it may be you still couldn't have had an exit by then because of other matters. And that's what he's investigating, isn't it?
My lord, yes, forgive me, I entirely understand. He's treating it as but-for causation,
Yeah.
as you would in a breach of contract claim for damages.
Yeah.
Exactly.
But
Sorry, go on.
no.
You say that's wrong, do you?
Yes.
It's a matter of law.
Yes.
So why is it wrong in the sense that, assume you're in a position the judge is in, he's found no breach of fiduciary duty, no negligence, no breach of section 174. So he's simply dealing with a director who has caused the company to breach a contract with shareholders. The contract is to provide the shareholders with an opportunity to exit. Nobody's obliged to exit.
My lord, that's wrong, actually. As I mentioned earlier this morning, there's a conversation we need to have, which I am planning to have, about the effect of clause 6.2 and 6.3.
Okay.
And it's a whole part of the case that the judge initially didn't deal with at all in his draft judgment, and we had to write to him, and then he inserts a paragraph dealing with this aspect of prejudice. The long and short of it is we say that clause 6.2 and 6.3, read together, certainly oblige an exit, and the shareholders are obliged to procure an exit in certain circumstances under those clauses.
That will make a difference, I think, conceptually, because I think the judge's thought process appears to have been, because the shareholders are not obliged to sell, or at least only if a certain proportion of them is achieved and they drag the rest, what the breach of contract that Mr Costa was said to have been responsible for leads to is the loss of an opportunity.
Yes.
And that can be valued in any contractual case. If what you've lost as a result of the breach of contract is the loss of an opportunity, you value the loss of the opportunity, and that involves questions of causation. What would have happened if the contract had been performed? And even though you've lost the opportunity, which is probably prejudice in itself, but it doesn't take you anywhere unless you demonstrate that it would have caused.
My lord, I agree. That was certainly the way the judge approached it.
Right.
We disagree in principle that, in fact, but-for causation would be the appropriate. Even in this kind of case where you're talking about a breach of contract, we think we suggest the unfair prejudice jurisdiction it's not a but-for test, and I'll come on to why we disagree with that. But actually the real point is that the judge misses/underplays entirely the actual prejudice suffered as a result of the complete failure to comply with 6.2 and 6.3 as a regime, because there comes a point under that regime where the shareholders are obliged to sell.
Right.
Or at least there is a very strong imperative that they sell, more than just they have a free hand. And that is missed with this formulation of relief. My lord, as I said a moment ago, there are two key respects in which we say the judge misdirected himself in law, and those are dealt with under ground 3. First, even though the judge held that Saxon Wood had suffered unfair prejudice within the meaning of section 994, the judge wrongly considered that the court was not permitted to grant relief unless the petitioner had actually suffered financial loss. We say that was a clear error of law and contrary to established authority. That's ground 3 sub 1. Secondly, and relatedly, the judge approached the question of relief on the basis that the objective was limited to remedying the immediate conduct that had given rise to the unfair prejudice. This is ground 3 sub 2. And just to elaborate on that, the immediate conduct that had been found by the court to be unfairly prejudicial in this case was the breach of clause 6.2, i.e. the failure to work in good faith towards an exit by no later than the 31st of December 2019, and the failure to give good faith consideration to opportunities for exit. So the judge approached the question of relief solely focused on the question of what would be required to remedy those breaches. That is, he approached the matter as you would a remedy for breach of contract, which goes to the conversation I just had with Lord Justice Zacaroli. And that led the judge to see the issue as simply being whether any financial loss had been suffered, again, as if you were in a damages claim. And we say that was too narrow an approach. If the court is satisfied that there has been unfair prejudice under Section 994, which the judge was in this case, then the court has a broad jurisdiction under Section 996 to make such order as it thinks fit for giving relief to the matters complained of. And there is good authority, which I'll come to, that this means the court should look to fashion a remedy that not only serves to deal with the immediate conduct, but will also be enduring. So those are the respects in which we say the judge misdirected himself in law. And then it's convenient to deal with ground 6. And the complaint under ground 6 is that because the judge was narrowly or too narrowly focused on whether any direct financial loss flowed from the breach of clause 6.2, he failed to take into account other matters which were relevant. In particular, he failed to give weight to the fact that Saxon Woods would, if it failed to obtain a buyout, remain locked into the company as a minority shareholder without the benefit of any obligation on the part of the company and the investors to work towards an exit, because the regime under clause 6.2 would no longer, would have been rendered effectively defunct. And this would be in circumstances where the company remains under the control of the person responsible for that breach. And not just responsible, somebody who'd been found deliberately to have caused the company to breach its contractual obligations to shareholders, fully in the knowledge that this was against Saxon Woods' wishes. So, under ground 6, we say the judge failed to take into account the bigger picture. And then the other ground of relief, appeal relating to relief is ground 4.
I mean, that ground 6, in a sense, is another manifestation of the creating an enduring remedy, is it?
Yes. As I say, my lord...
I appreciate you said these all sort of...
They do flow into each other a bit. Ground 4, finally, looks more particularly at the buyout relief that was made with the conditionality attached. And as I said before, we say that was not a fair and equitable remedy for the prejudice. And that's because it gives insufficient weight to the prejudice that had been and continues to be suffered by the petitioner. So overall, in relation to relief, our position is the judge should have made an unconditional order for the purchase of the shares, and his failure to do so is down to misdirecting himself in law, failing to give sufficient weight to the prejudice actually suffered, and failing to take into account the bigger picture, as I said. And specifically, he should not have imposed the burden, and it is a significant burden, on the unfairly prejudiced petitioner of having to prove at a further trial that in the particular counterfactual scenario, a binding offer for the company would have been made in an amount in excess of $75 million. And as I say, it's a significant burden, given that in reality, and over a period of many, many months, Mr Costa failed to follow and indeed undermined the exit process. So the unfairly prejudiced petitioner is given the burden of having to establish what the best price would be and operate in an entirely counterfactual world, in circumstances where it was excluded effectively from what was actually going on and not privy to the kind of information that the company and Mr Costa had. So that's a brief trot through the grounds of appeal and how they operate, just by way of summary. If I can now take your lordships to the findings that the judge made, and in the judgment, tab 13 of the core bundle, and starting at paragraph 253, you see a heading there, it's on page 268. And so paragraph 253, and this is the reference to the gamble that spectacularly failed, we see there. And then 254, if the company had performed its contractual obligations to consider all offers, it would have had at least one or two conditional offers on the table by the end of the investment period. If it had properly instructed Jefferies, it might well have had more. The extent of the loss suffered by the petitioner as a result of the unfair prejudice which it has suffered is therefore, to my mind, simply a function of the value of the best offer which the company would have received. And this goes to Lord Justice Snowden's point a moment ago. This is how the judge saw the position. But of course, that very much reflects the focus of the judge on seeking to identify financial loss flowing from the unfair prejudice. And then paragraph 255 is the first reference we see to the so-called quantum trial. It says there will therefore need to be a further hearing. And then 256, the judge elaborates on the purpose of the quantum trial. See 256. So he refers to the metric offer. He says that would have complied with an exit. Both experts accepted that the offer process would have proceeded through a process of initial offers followed by due diligence by the offerors, followed by final binding offers which may well have been lower than the initial offers. The question to be determined at the quantum trial is, therefore, at what level an offeror who had done proper due diligence on the company would have pitched their final binding offer.
I mean, is that anything other than saying what is the market value of this company between a willing buyer and a willing seller? What's the difference?
That's the end point of the analysis, but what the judge envisages, as we see further in his order, is the experts effectively taking into account, for example, the due diligence process. How would that work? How much due diligence would there be? I mean, a company can give lots of due diligence or not much due diligence. It's just uncertain, but the experts have to take a view as to what that process would have been, what impact it would have had. It can have a different impact depending on how many bidders are involved. If you've only got one bidder, you might give them not very much due diligence. Or maybe you have the opposite approach.
But normally on a 994 buyer valuation, the experts are asked to value the company at a certain date, fixed by the court, and on the basis of various hypotheses, usually, as it were, adding back the value which has been lost by reason of the usually misfeasant director's misconduct. And so values are often required to hypothesize about the effect of the breaches of duty that have usually led to the buyout order. So why is this so radical?
My lord, I would suggest there's a difference in kind between, for example, having to adjust a valuation for a misappropriation of assets.
Yeah.
It's basically an arithmetical adjustment on the one hand.
It might be or might not be, because it could be a diversion of a corporate opportunity, which is often, just siphoning off an opportunity into another company. And the question is, well, okay, but...
So, my lord, yes, it might be a more complicated matter, but it's still a question of a discrete adjustment to what would otherwise be the valuation of the company.
Okay.
Whereas this is, as I said before, I might be able to come up with a different form of words, but this is giving the experts purview over a process that should have been running over 9 months as to how that should have operated. And in the market as it was at the time, in circumstances where, as I say, you had Jefferies working, you had potential differences of approach in respect of due diligence. It's giving the expert, asking the expert to opine on the process and how that would impact on value, as well as asking the expert to opine on value. Ultimately, the expert is being asked to opine on value. I entirely accept that, my lord. But it's asking the expert to do a lot more than is normally the case in my respectful submission. And if we move on, in paragraph 257 to 258, the judge elaborates on his reasoning for imposing the condition on the buyout. And, my lords, you have this point as to what the judge, his approach was, and his reasoning for adopting the 75 million figure. which is in 258. And we say that's, we'll come back to that, but we say there's no proper basis for that figure in any event, but that's where it is. And then in paragraph 259, we see the judge setting out the parameters, the key points at least, as regards the counterfactual that he would ask the experts to be considering, including the company should have instructed Jeffreys that it was required to seek offers, the company should have given due consideration to the offer from Metric, and progressed the contact with THG. That's the Hut Group. And then the key paragraph on this aspect of the appeal concerning the judge's approach, the question of relief, is paragraph 261. In the event that it is concluded that any offer received would have been below $750 million net of debt, then I find that the petitioner has suffered no loss caused by the unfair prejudice. Now, pausing there, we'd say that's a somewhat revealing formulation because it suggests that the judge thought that even after establishing prejudice, it's necessary to determine loss. We say that that's an insight into a misguided approach. It's the unfair prejudice itself that's the gateway to relief. There's no need to establish loss on top. And the point is reinforced by the remainder of the paragraph. Now, I'll come back to ROC nominees. Halfway down the paragraph, he says, in the interest of clarity, I should emphasise that this does not imply that there was no prejudice, nor that it was not unfair. As I say, I accept that the petitioner has suffered unfair prejudice. So naturally, that couldn't be a clearer finding. He reiterates it. He says it's for clarity.
Although, does he anywhere spell out what the unfair prejudice that he has found actually was?
Well,
or do we infer that from other things that he talks about?
It's inferred, my lord, from the findings of breach of clause 6.2, which
Yes.
are elsewhere earlier in the document. As to prejudice, it would seem that he takes the view that in order to allow for relief to be given, a mere finding of prejudice is not enough. You need financial loss as well. And that he makes that explicit in the last sentence because he says, however, where it is clear that the unfair prejudice suffered by the petitioner has not in fact caused him any loss, then I do not think that the broad equitable principles which I am required to apply in considering a petition for relief permit the grant of any such relief. So we say that's contrary to authority and wrong in law. Section 996 is absolutely clear. If the court is satisfied that there's unfair prejudice, it can grant relief. There's no requirement for loss on top.
Well, I mean, for example, if the shareholders agreement requires there to be no more than 5 directors, well, the articles permit more, but the shareholders agreement say there must be these directors on the board, and the majority appoint another one. You'd say it's plain unfair prejudice,
Yes.
but they may not have done anything wrong and there's no loss, but it doesn't mean that the court couldn't grant relief to say you must remove the surplus director who breaches the shareholders agreement. I mean, that seems obvious.
Yes, and in a normal exclusion case, you wouldn't necessarily be able to point to loss.
Perhaps too wide, as it's stated, as a broad proposition, but where the contract is actually related to an exit, i.e. a sale of an asset at a price, it's all to do with money. Why isn't causation a relevant question?
My lord, again, it depends upon whether or not the shareholders had a free hand to reject the offer.
Okay, well, we're going to...
Because if they don't
That's
have
the
a free
conversation we're going to have.
Yes, yes. But to your point, otherwise, well, my lord, it might be part of the appraisal by a judge as to what the appropriate relief is. One can understand that, absolutely. But what you have here is a judge stating it as a principle.
Yeah.
And that's clearly wrong. And unfortunately, it suggests he was thoroughly misdirected as to his approach to relief, because he is explicit in reiterating he's found unfair prejudice, but then he says, I'm not permitted to grant relief unless I can show financial loss. There's no other way of cutting it. That is exactly what he is saying there in clear terms, and that is obviously wrong. And that, unfortunately, was the bedrock of his decision to make a conditional buyout order.
Just going back to my Lord's question earlier, so what is the prejudice the judge found? And what do you say the prejudice is?
The judge, I would suggest, based prejudice on the loss of a realistic opportunity to achieve an exit, but required it to be shown that that exit would have been achieved.
Yeah. So if you ignore his reference to identifying financial loss, it might be that what he's saying here and elsewhere is actually there's prejudice which has no material consequence if in fact you couldn't have exited anyway. And that's why
I suspect that is what he was thinking, yes.
Yeah.
But his description of the law is incorrect here. If that was the way he was thinking, he should have made the point your lordship makes as part of an explicit discussion of relief, not as what the appropriate relief would have been, as opposed to a discussion around prejudice. So he's clearly stated a finding of unfair prejudice, and he's then added an extra ingredient. If his actual view is there's no prejudice unless a sale would have been achieved in the counterfactual world in excess of 75 million, that is what he should have said. And he doesn't say that, but I imagine one can surmise, but it's possible that's what he was really thinking.
Might be slightly dancing on a pin at this stage, but you can analyse it two ways. One, there is no prejudice because had Mr Costa acted in accordance with his obligations, he would not have exited anyway, as it happens. Or there is prejudice because he failed to act properly, but that no consequence flows from that unless it can be shown that it had any causative effect. Not in terms of financial loss, but causative effect in enabling you, in preventing you getting out.
Yes, he might have put it in those ways.
But those are two different ways of putting the same point, which is one of those, is either of those right on your analysis? Or are they both wrong?
Excuse me, my lord. Well, my lord, we say that the breach is in itself prejudicial because it's a shareholders agreement governing the ongoing relationship between the parties. So certainly we say there is prejudice regardless of it needing to be proved that there was financial loss.
When you say unfair prejudice, Lord Hoffman is acting in a manner contrary to the agreement between the parties as to how the affairs of the company shall be conducted.
Yes.
I'm very badly paraphrasing.
But I'll take your lordship to Edwardian Group,
okay, well,
Justice Fancourt.
I like to go back to the,
the original.
Phillips, before your time, perhaps, but that's where I cut my teeth.
Indeed.
So you say that it's acting contrary to the understandings between the parties.
Yes.
And that itself is unfairly prejudicial.
Yes.
So you say it opens the door.
Yes, to 996.
And to which, and if the judge said anything else, he was wrong.
Yes.
But just because you're in
the right on the interpretation of the law.
Just because you're in the sweet shop,
yes,
doesn't mean you can have everything you want.
No. Hence the dancing on the pin comment I think my Lord Justice Zacaroli mentioned. So we do need to explain our case as to why the relief is given is not suitable and not adequate to remedy the prejudice that has actually been suffered.
Yeah, you have to actually say it's wrong in principle, or a relief that no reasonable judge could have given, because otherwise I don't see at the moment how you get the Court of Appeal to interfere with an exercise of discretion.
Well, I understand that, but it's a good start. I would suggest that the judge has, we suggest, completely misstated the way the law works in paragraph 261.
Okay.
where he says the broad equitable principles which I'm required to apply do not permit me to grant any relief.
My Lord, yes. That was the bedrock of at least his decision on relief, and it was completely unsound. Now, my Lord, when we received the draft judgment, and this is, I appreciate this is possibly an unusual tack in the context of an appeal, but I do want to show you two documents that have also arisen around this judgment. And we wrote to the judge because we had concerns about the conditionality of the order. And at that point in the judgment, it was just based upon a breach of clause 6.2 in the sense of failing to work in good faith towards an exit by the end of 2019 and failing to give good faith consideration to opportunities for exit. And the letter is in the core supplemental bundle, tab 50, page 290, and in the supplemental bundle at bundle 2, tab 56, page 1180. So you should, I hope, one way or another, have a letter from Stevenson Harwood of the 7th of February 2024. And you see that the draft judgment was made available, and then Stevenson Harwood wrote, referring to the proposed direction of paragraph 260, that there be a further hearing subject to this threshold of $75 million. Certain aspects, the second paragraph, certain aspects of the approach in the draft related to quantum trial are not clear to the petitioner, potential cause for concern. And then in broad terms, the issues in respect to which the petitioner seeks clarification are twofold. First, there's an issue as to evidence required for the purpose of the quantum hearing. And then Lordships can read that paragraph, but you can see that concern was, well, how are parties to approach this question of what offers would actually have been made in the counterfactual situation, given that both parties' experts have already opined that even on the basis of a starting point of the 1st of March, there was enough time to achieve a sale. It's possible initial offers might be adjusted following a process of due diligence. The likelihood and extent of any such adjustments would depend upon the particular facts, and asking for guidance as to how one would go about doing that. For example, should there be additional factual evidence from market participants or metric, for example? Then the second main point was more substantive and concerned the draft judgment's approach to prejudice. There's a point raised about the evidential basis for the 75 million. And then towards the bottom of that second page, you see a paragraph, in this regard, we observe that the draft judgment does not address the petitioner's alternative case on the issue of prejudice. Thus, the petitioner's case in respect to the first phase of the exit process was that prejudice was also established by reason of the fact that members of the company were deprived of the opportunity to consider what offers might have been available. And then you can see a point made, it's not a claim for damages. And then I think the most substantive bit is over the page, top of page 292 in the core bundle. In respect to the second phase of the exit process, the obligations under clause 6.2 changed. At that stage, the directors became subject to an obligation to cause an exit at a valuation devised by such investment bank. And importantly, if the terms of the exit were put to them, the shareholders were obliged to proceed with the deal pursuant to their obligations under clause 6.3. And then that's obviously, because it's under the agreement, can only be varied with the unanimous consent of the members. So then, whilst the court has accepted that there was a breach of clause 6.2 in respect to the second phase, the draft judgment does not address the petitioner's case as to the ramifications of the second phase breach. In particular, on the issue of prejudice, the petitioner's case was that if the company had performed its obligations in respect to the first phase, it ought to have been in a position to present an offer for acceptance by the shareholders very early in 2020. Shareholders would then have been required to deal with such an offer in accordance with second phase obligations under clause 6.3. In short, they would not have had a free hand to reject the offer. And then the point is made that the only way around this would have been them to persuade Mr. Lloyd to agree to a variation of the terms. And then at the bottom of the page, there's a suggestion there's a further written submissions on the point to assist the judge. And it's asked that the formal hand down is deferred, so these additional issues in respect of prejudice can be dealt with. Now, what happened was, in the event, there were no further submissions. The judge had indicated he was willing in principle to have further submissions, but the respondents objected. So instead, the judge produced a final judgment, which was amended in certain respects to deal with some of these points. And importantly, in relation to the ground of appeal I'm currently referring to, the judge clarified and confirmed that he was satisfied that there had been unfair prejudice. So, paragraph 261 of the judgment, which I just took your lordships to, which is the one that says he's not permitted to grant the relief, that paragraph was not in the draft. And your lordship will recall that that's where the judge makes it absolutely clear that he is making a finding of unfair prejudice. But nonetheless, of course, in the final judgment, the judge stuck to his guns as regards the $75 million threshold. Now, I'll come, as I say, we did raise the point that we didn't consider the judge had dealt with the prejudice arising from the failure to follow the clauses after the end of the year, where the obligation becomes more stringent, and I'll come back to that. The other document I want to show you, lordships, is the consequentials judgment.
Is it right that 262 was in some way either amended or the product of this letter as well? It seems as if all that happened was 261 was added, that seems a bit bizarre. I mean, surely 262 was also. So, my lord, that what I mentioned, I was going to come back to deal with how the judge then sought to deal with our complaints. That is 262, lordships, because that's quite right. That was also added. Yeah.
And we say it's not an adequate response, but I'll come back to that. Yeah. The consequential judgment also provides some insight into the judge's thinking around this judgment, and that's at C279. It's tab 14 of the core bundle. Now, it's unusually a 25-page consequentials written judgment. And you'll see in paragraph 1 on page 281, the judge sets out the particular matters that he's proposing to address. I'm only currently concerned with item 1, directions for the trial of issues on quantum. And the central issue here concerns how the court would deal with the need to determine whether the 75 million threshold would be beaten. And the judge sets out his thinking on that in paragraph 7. On page 284 of the bundle, and you see the judge says the question is to be answered on the basis of expert evidence, so no additional factual evidence. And then 8, the judge says this process must be conducted on a somewhat abstract basis. It is not possible to form any clear picture of what the position might have been had Mr Costa and the company acted properly, or which bidders might have been attracted on what basis or when. It is no part of the hearing to determine whether any specific bidder would have bid or not, with one partial exception. It should therefore begin with a purely hypothetical bidder and inquire what the level of any final binding offer following due diligence would have been. So, again, going to my point that this is a more involved exercise that the experts are being asked to indulge in my respectful submission, that paragraph encapsulates the problem. On the one hand, the judge is saying it's abstract, yet he's setting out in his order some fixed parameters, and then saying it's not possible for the for the experts actually to form a clear picture of what the counterfactual position would have been. But surely the whole point is for them to try and form a picture of what the counterfactual position would be, and that then informs how they go about their valuation. So in my submission, it's a rather confused picture. And then paragraph 9, any exercise establishing the likely market value of a company must pay close attention to the factual position in which the company finds itself. But again, how does that fit with his comment in the previous paragraph that it's abstract and it's not possible to form a clear picture of what the position might have been? In the very next breath, the judge says the valuer must pay close attention to the factual position. Then he says, in particular, because of the disclosure which has already been made, in this case, the experts will have access to much fuller information than an actual bidder would have had. I do not think that fact advantages or disadvantages either side. So it's then said that the experts are not going to put themselves in the position of an actual bidder, but are going to have more information. And then he deals particularly with metric, and it will be necessary to consider the particular position of metric. However, it would be an irrelevant distraction to conduct a factual inquiry as to what metric would have bid. The inquiry should be solely a valuation inquiry as to what it might have bid. But again, for myself, I'm somewhat at a loss as to what that means, or as to what an expert would make of it. But that's...
But I say surely an expert valuers, if there's a market or there have been offers, actually they normally go by consummated sales of comparables, if you're doing a piece of property. Or if there's a market for the unique piece of property, they would undoubtedly they should take into account bids at whatever level of certainty the bids are.
Yes.
And then give them such weight as an expert would do. That's what experts do.
And we do have the metric bids, or there weren't formal bids, of course, there were expressions of interest.
Yeah, but it's a piece of evidence that you would, if you're an expert, be able to take into account and either give it no weight or such weight as you think fit. I mean, that is part of the valuation exercise, isn't it?
Absolutely, my lord. And the judge is clear in saying that they should take into account the metric expressions of interest. What, in my submission, is confusing about these passages is the extent to which the experts are supposed to treat it as an abstract, to use the judge's word, exercise, or an actual attempt to recreate an accurate counterfactual or a thorough counterfactual picture, because he seems to be saying both things. My lord, an expert, with given the task, could no doubt come up with a number. I mean, I'm not suggesting this is impossible to operate. I am suggesting it is unusual, and in asking the experts to take into account a counterfactual regarding a process that was run over 9 months, with multiple variables around what would have happened with bidders and due diligence and Jeffreys and etc., is unusual, and
But it's everyday bread and butter in the King's Bench division if somebody's bringing a claim for breach of contract and valuing the loss of an opportunity, isn't it?
Well, my lord, I would suggest that here this is not normal for an unfair prejudice valuation, where, as I said, the valuer looks at the value of the company at a particular point. They're not having to, prior to that point, assess what would have happened regarding the shape of the market for this particular company in a counterfactual situation. That makes this an novel, as far as I can understand, approach.
Part of the problem, the interplay with the schedule to the order we saw, because it looks like the schedule is requiring the experts to start from the proposition that there would have been certain offers.
Yes.
At least one or two conditional offers on the table by the end of 2019. Is that the problem? It isn't just saying what would have happened had a marketing process begun in April.
Yes, so various fixed points. He gives various fixed points and that must be taken into account. And then more broadly says, one takes into account my judgment. And then in the consequential judgment, he says it's abstract but yet you have to take into account the factual position that the company would have found itself. So it's a mixture of directions in an unusual process where the valuer is not just valuing the company, they are taking into account issues around how the process would have. So one can imagine having two different kinds of experts. I mean, you can imagine at the trial, there were experts regarding investment banking and how you go about selling companies. They were the experts we had at trial, and they're the people that can talk to the questions, and indeed did talk to the questions concerning what sort of due diligence one would have, how long the process would take, what the market looked like. That's actually that's not necessarily the same person as a share valuer. I mean, it might be the same person, but it's not necessarily the same person. It's a different discipline.
But if your appeal succeeds on this, as I understand it, what you're basically saying is that you should take away the 75 million floor, FLOOR, and there should be a buyout at a valuation.
Yes, as at the end of December 2019.
So, and in conducting that valuation, a valuer will have to say, well, what would somebody have paid in a properly conducted process?
Well, I think given that the process was not properly conducted, it's quite difficult for us as the petitioner to recreate that entire history.
But normally, the market value that a valuer arrives at is one which has been properly conducted. I mean, the classic negligence claim against let's say, an administrator, is that they failed properly to test the market for the property of the company in administration that they flogged out the back door. And so when they are sued for damages for failing to conduct, for breach of duty, the experts have to say, well, what would this property have fetched if there had been a proper marketing process with full publicity? I mean, so it's just bread and butter for experts to express a view as to value if there'd been a proper process, and if the process is a very specific one because it's a very particular type of asset that is to be marketed, then you may have to have two experts. But why is that so objectionable? I'm struggling to understand why this is so objectionable it was wrong, or in fact what you're asking us to do.
Well, my lord, if we succeed, if we get an unconditional buyout, we will have what I would describe as a conventional valuation or quantum hearing, where you have two experts giving their opinion on the value of the company as at the end of December 2019. And they can do that in various different ways. One would expect them to look at a multiple of profits, a multiple of revenues, and to test that against comparable company sales in the market at about that time. All of those things would be entirely conventional in my submission. What I would suggest is less likely and unusual would be that the expert then imagines feels the need, frankly, to run through an artificial sales process in respect of the company. I mean, of course, that's the premise of the whole exercise. One is seeking to figure out what the fair market value of the company would have been, but it doesn't require you to run a counterfactual analysis of what the sales process, what the figures would have looked like, or what the market would have looked like if a sales process had been properly managed. We're not asking for that to be done. It would just be a question of the valuer looking at the figures, looking at the market objectively, and saying what would that company have fetched in the market. Of course, our main concern is the threshold of 75 million. And in a sense, that's the concern. But
here you're picking holes, I think, in the way in which the judge required this.
And I should stop because it is a bit of a distraction to the main effort. I'm trying to just illustrate that there are unusual aspects to where we've ended up here, and it's not immediately obvious how it's to be dealt with. So I want to move on to the actual legal grounds, so where the judge misdirected himself. So 3.1, the judge went wrong in equating prejudice with financial loss. I've made the point already. I've taken your lordships to paragraph 261 of the judgment. What was particularly odd is if one looks at paragraph 130 of the judgment, which is at page 206. 216. That's a bad reference. I'll come back to that. I should take your lordships to the authorities. Firstly, Coroyne, which is a case that I'm sure you're familiar with. That's in the authorities bundle, tab 3, bundle 3, tab 28, page 867. It's a well-known case regarding a battle for control of Claridge's amongst other hotels. Mr Justice David Richards, as he then was, and he provided an authoritative treatment of the law of unfair prejudice, which I don't think will come as any surprise to anybody, but I just wanted to take you to it because it's a helpful summation. It starts at paragraph 624, but the treatment of prejudice is at 630.
Could you give me a page reference?
It's 1019, 1019. And in a well-known passage, it's paragraph 630, the judge pointed out, obviously, that prejudice will certainly encompass damage to the financial position of a member. And then your lordships can read down towards the bottom of that paragraph. The prejudice must be to the petitioner in his capacity as a member, but this is not to be strictly confined to damage to the value of his shareholding. Moreover, prejudice need not be financial in character. A disregard of the rights of a member as such without any financial consequences may amount to prejudice falling within this section. Where the acts complained of have no adverse financial consequences, it may be more difficult to establish relevant prejudice. This may particularly be the case where the acts or omissions are breaches of duty owed to the company rather than to the shareholders individually. If it is said that the directors or some of them had been in breach of duty to the company but no loss to the company had resulted, the company would not have a claim against those directors. And that's the Rock nominees case. So if your prejudice is said to result from a breach of duty by a director to the company which caused loss to the company, and at a trial you fail to establish breach of duty, there's obviously no prejudice. But that's the result of how you put your case to start with, being a breach of duty to the company. And over the page you'll see that Lord Justice Jonathan Parker in Rock Nominees, again a well-known extract, makes that point. In the Rock Nominees case, however, no harm was in fact done and no damage or prejudice caused. So in that situation, it seems to me to be inappropriate to reach a conclusion that they breached their fiduciary duties, as it were, in the abstract. So that's the particular situation where the alleged unfair prejudice is a wrong to the company itself, said to have caused loss. Of course, if you fail to establish that, there's no prejudice. The next case I'd like to take you to is the Edwardian Group, which I mentioned a little bit earlier. That's at tab 36 of the fourth authorities bundle, which is page 1288. This is Mr Justice Fancourt. It's another hotel company unfair prejudice case. And in this case, the unfair prejudice petition was upheld on various grounds and a buyout order was made. And we get that from the holdings, the 10th paragraph of the holdings, which is on page 1294. So the proper relief for the prejudice caused to the petitioners by the breaches of fiduciary duty and his willingness to conceal matters that should have been disclosed to the board's weakness and willingness to support JS rather than act truly independently, to leave wrongdoing covered up, to mislead shareholders about its true nature, and to distribute corporate profits improperly to JS by way of disguised and unreasonably high remuneration, instead of as dividends to all shareholders proportionately, was an order that JS or the company purchase the petitioner's shares at a fair value. So that was the relief. And then we rely on the case for the statements made by the judge on the law and in relation to prejudice in particular. And that's dealt with at paragraph 338, which is on page 1373. And you see a subheading there, what prejudice was caused by the breaches of fiduciary duty? 338. JS contends that even if he acted in breach of fiduciary duty, as I have held that he did, those breaches of duty caused no loss to the company, and accordingly that misconduct of the company's affairs was not unfairly prejudicial to the interests of the shareholders generally, or to HS and Estera in particular. The breaches of duty as regards Winchfern and Exportel by their very nature caused all the shareholders prejudice, in that JS was wrongly putting himself in a position where his duty to the shareholders of the company conflicted with his own interests and then preferring his own interests. That kind of conflict is corrosive of good administration and trust between shareholders and directors. Further, the prejudice was by its nature unfair. The members did not know of JS's personal interest. They were unaware of the undisclosed conflict that the CEO of the company continued to have. They were deprived of the right to give or refuse consent to JS taking the opportunity for his personal benefit. Now, obviously, all cases are on their own facts, but there's certainly, we say, some resonance there with aspects of our case as well. And we see over the page, the judge referred to Coroyne. It's the top of, so bottom of paragraph 340. That judge made it clear that unfair prejudice does not have to be financial prejudice, while observing that where a company suffers no financial loss, it may be harder to identify unfair prejudice. So we rely upon that case as showing that clearly you don't need financial loss for prejudice. And then over to 345. As for JS's continuing breach up to 2008 of his duty to disclose his conflict of interest, there is no evidence to suggest that that loss was actually caused to the company as a result of commercial or other dealings between the company and Expotel. On the contrary, it appears to me likely that the company continues to benefit considerably from the business of Expotel. However, the failure of JS to disclose his continuing conflict of interest and duty, and when he did give disclosure, doing so in a partial and misleading way that was calculated to conceal the true position, prejudiced all the shareholders in the general way that I've indicated in paragraph 339 above. So we say the conduct of Mr Costa here was equivalent to the conduct referred to by the judge in that case. It was inherently prejudicial to the other shareholders and investors. Now, the judge in paragraph 261 referred to Rock nominees as the basis for his finding that financial loss, absent financial loss, he was not permitted to grant relief for unfair prejudice. Now, I referred to Rock nominees. Rock nominees was referred to in the Coroyne judgment, and I've just addressed that. The short point is that in Rock nominees, the allegation was of the transfer of a subsidiary company to a connected company at an undervalue. That was the basic complaint. It was a claim that the directors had breached their duties by selling at an undervalue. So the prejudice, if any, would only arise from the loss to the company, ultimately, as ultimately reflected in the shareholders' interest in the company. But of course, if the petitioner fails to establish that there had been a transaction at an undervalue, which is what happened in Rock nominees, there can be no prejudice, because that was the sole prejudice referred to. So the case stands for no more than the proposition that if your unfair prejudice petition is founded on the basis that you have suffered prejudice due to loss caused to the company, and you fail to establish that any loss has been caused to the company, then your case will fail for lack of prejudice. But if your case on prejudice is broader than that, and it doesn't depend on a particular transaction or a particular loss to the company, then of course you can establish prejudice in different ways, which is what we seek to do. So we say the judge clearly misdirected himself in holding that it was a prerequisite for the grant of a buyout, the buyout sought by Saxon Woods, namely an unconditional buyout, that Saxon Woods established that it had suffered financial loss as a result of the failure to achieve a sale by the end of 2019. So that's ground 3, sub 1. Ground 3, sub 2 is the point about adopting an overly narrow approach to the relief. My Lord, I wonder if this might be a convenient moment for a break. Otherwise, before I launch into this next section.
I think it would. Do we need to have 10 minutes again?
Well, 5 minutes would be fine for my part.
Well, let's do that.
Thank you.
All rise.
keels over, maybe.
You've got another one there.
Oh, thank you.
Go to the end of today.
I think so.
No, that's fine. No,
Yeah, I'm hoping to finish the end.
fine. I mean, if there's 5 or 10 minutes left, I'll just say I'll start tomorrow. It's probably easier.
Yeah, it doesn't make much sense for a start.
Don't take it personally, but there's a book on the bookshelf there, Civil Liberties. So I'm just wondering what they have in mind.
Why?
Thank you, my lord. I was moving on to the second part of our third ground of appeal, ground 3 sub 2, which is that the judge adopted an overly narrow approach to relief under section 996. So this relates to the first ground. So in the sense that just as it's not a prerequisite for a finding of unfair prejudice that the petitioner must be show that there was some financial loss, where the court is satisfied that there has been unfair prejudice, the relief does not have to be directed solely at compensating the petitioner for any direct financial loss that they have suffered. It's established that the court can and should take a broader approach. So here, the judge wrongly approached the question of relief as solely concerned with compensating Saxon Woods for any financial loss that it could show at a further trial that it had suffered. Again, as if it were a claim for damages. And that in turn led him to fashion a form of relief designed to ensure that unless Saxon Woods could prove at this further trial that the buyout would have been in excess of 75 million, there would be no buyout. So he ignored the broader scope and purpose of the power to give relief under section 996. And I'll take your lordships to some authorities on that now. Firstly, Bird Precision Bellows. It's in the first authorities bundle, tab 8, page 147. It's a decision of the Court of Appeal, 1985. Petition under section 75 of the Companies Act 1980. the terms of which in respect of relief are the same materially as under section 996. The petition was brought by minority shareholders who'd been excluded from management, and the court made a buyout order by consent. So the proceedings then continued for the purposes of determining the price. And it was in that context that the court determined that the company was a quasi-partnership, so that the shares would be valued without any discount for minority. On the appeal, the majority respondents argued that a buyout order under section 74(4)(d), which is now section 996 sub 2e, should be interpreted as requiring the shares to be valued as they were. So without any adjustment for minority or indeed majority holding, so just the market price. So, as your lordships will be aware, under section 996, as with its predecessors, it does in fact give examples of the types of relief that can be granted, which include a buyout order. So the particular appeal here was that if you're going under that particular subsection of 996, the valuers just value the shares as they are. Now that proposition was roundly rejected by Lord Justice Oliver. In doing so, he made some comments which are of more general application regarding the court's approach to relief under this jurisdiction. And if I could ask you please to go to page 6, paragraph 66, no, beg your pardon, page 669 of judgment, which is page 158 of the bundle. And you see it letter D, delta. For my part, I find myself quite unable to accept this submission. It seems to me that the whole framework of the section and of such of the authorities as we have seen, which seem to me to support this, is to confer on the court a very wide discretion to do what it is considered fair and equitable in all the circumstances of the case. So, my Lord Justice Snowden, that's one instance of that formulation at least being adopted.
Pre-O'Neill and Phillips.
Pre-O'Neill and Phillips, indeed. To what is fair and equitable in all the circumstances of the case, in order to put right and cure for the future the unfair prejudice which the petitioner has suffered at the hands of the other shareholders of the company. And I find myself quite unable to accept that discussion in some way stops short when it comes to the terms of the order for purchase and the manner in which the price is to be assessed. So, the facts are rather different from our case, but these dicta are helpful, we say, in illustrating the breadth of approach that the court has to this jurisdiction, and also the fact that it has an eye to the future. After all, the unfair prejudice jurisdiction is for regulating the affairs of companies which continue on. It's not a normal cause of action, and that is why the court is given a broad discretion.
Yeah, but it's to cure for the future the unfair prejudice which has suffered. It's not saying it's a roving mandate to arrange the affairs of the company in the way the court thinks would be jolly good if the parties had even had thought about it all for the future. It's not some sort of marriage guidance council for companies.
I entirely agree, my lord. And it has to relate to the unfair prejudice that the court has found.
Yeah, and so, for example, it could be if somebody had been threatened to be excluded, the court would say, no, for the future they shall not be excluded, but it has to relate to the threat or the actual unfair prejudice that's been complained of.
My lord, yes. It does so happen, though, that quite often the court thinks about this hard and realises that the best approach is a buyout.
They have to go their separate ways. Yes, absolutely. Very often. It can often be the case.
Yeah. The next authority is Grayson Biagioli, which is the second authorities bundle, tab 20, page 407. It's another decision of the Court of Appeal. Post O'Neill and Phillips, pleased to say. And here we're talking about section 459 of the Companies Act, the equivalent provision under 1985 Act. The petitioner had succeeded at first instance in establishing unfair prejudice on grounds of non-payment of a dividend in this case. But he had failed in relation to his exclusion case. The judge declined to make a buyout order and had instead held that the appropriate relief was an order requiring the company to pay the petitioner the missing dividend. So perhaps this case may access the point that Lord Justice Snowden is making about what would appear to be a more financial type of prejudice and how one approaches that. And certainly the first instance judge in this case declined to make a buyout order. Now, the petitioner appealed against the decision to dismiss his exclusion complaint and against the relief. In relation to the latter, on relief, the petitioner argued that the refusal to make the buyout order was wrong in principle and failed to take into account the broader picture, given the breakdown between the parties and also the seriousness of the respondent's conduct. The appeal in respect to the exclusion complaint remained dismissed. So regarding the appeal in respect to relief, the relevant passages start at paragraph 73, which is page 429 of the bundle. And Miss Justice Patton giving the judgment. Mr. Justice.
I think he was sitting up.
Yes. Yes. So paragraph 73, once unfair prejudice is established, the court has given a wide discretion as to the relief which should be granted. Although section 4611 speaks in terms of relief being granted in respect of the matters complained of, the court has to look at all the relevant circumstances in deciding what kind of order it is fair to make. It is not limited merely to reversing or putting right the immediate conduct which has justified the making of the order, and cites third precision bellows. Carrying on. The prospective nature of the jurisdiction is reflected in the fact that the court must assess the appropriateness of any particular remedy as at the date of the hearing and not at the date of the presentation of the petition, and may even take into account conduct which has occurred between those two dates. The court is entitled to look at the reality and practicalities of the overall situation, past, present and future. It was therefore incumbent on the judge to consider the whole range of possible remedies and to choose the one which, on his assessment of the existing state of relations between the parties, was most likely to both to remedy the unfair prejudice already suffered and to deal fairly with the situation which had occurred. The principal criticism of his judgment on this issue is that he concentrated on the precise nature of the prejudice already suffered, i.e. the non-payment of the dividend, but failed to look at matters in the round. In particular, no adequate regard was paid to the fact that the respondents had in effect helped themselves to the dividend, to which Mr Grace was undoubtedly entitled, nor to what is said to be the overwhelming likelihood that similar acts of prejudice will be suffered in the future. In most cases, the usual order to make will be the one requiring the respondent to buy out the petitioning shareholder at a price to be fixed by the court. This is normally the most appropriate order to deal with intra-company disputes involving small private companies. And this is the relief which Mr Grace says the judge should have granted and which he seeks on this appeal. The reasons for making such an order are in most cases obvious. It will free the petitioner from the company and enable him to extract his share of the value of its business and assets in return for foregoing any future right to dividends. The company and its business will be preserved for the benefit of the respondent shareholders, free from his claims, and the possibility of future difficulties between shareholders will be removed. In cases of serious prejudice and conflict between shareholders, it is unlikely that any regime or safeguards which the court can impose will be as effective to preserve the peace and safeguard the rights of the minority. So we obviously rely upon those dicta as highly relevant in the present case. And ultimately, in that case, it was held that and we see this in paragraph 85 of the judgment, that the judge had exercised discretion in relation to relief on too narrow a basis and that a buyout order should have been made. So even in the context of a complaint that was manifestly a purely financial matter concerning dividends, it was seen that a parting of the ways was the appropriate order. So, having found that there had been unfair prejudice, we say the judge misapplied the law in these two ways. Firstly, he considered he was not permitted to grant relief unless there was financial loss, ground 3 sub 1. And secondly, he considered that any relief had to be strictly limited to compensating for any financial loss that the petitioner could ultimately show that they had suffered. And that's ground 3 sub 2.
I mean, as it happens, Grayson Fagioli was a quasi-partnership company.
It was.
Yeah, and the reference to small private companies where these observations are entirely apposite.
My lord, that is a distinguishing feature. I accept that. I would say, though, there are only a small number of investors in this company, and whilst one doesn't have the informal bonds that one sees in a quasi-partnership, we have the formal bonds of the Shareholders Agreement. And so in a sense, if that has been breached, as we say it has, in a way that fundamentally undermines the relationship, my submission, the principles set out here should apply with just as much, if not more, force. And it is also, I'm grateful to my learned junior, important to recall that the particular obligations we're concerned with are explicitly obligations of good faith. So those were the respects in which we say the judge went wrong in law. And having set himself up on that thoroughly unsound footing, he then made two key errors in the exercise of his discretion in relation to relief. Firstly, this is ground 6. He made a similar mistake to that made by the judge in Grace and Biagioli. So as a result of his misguided concern to ensure that his order was strictly limited to remedying the financial relief that Saxon Woods would be able to prove that it suffered, the judge overlooked the broader situation. Specifically, he failed to take into account the fact that unless Saxon Woods was bought out, it would remain locked into the company as a minority shareholder. And that would be in circumstances where the protection that Saxon Woods had previously enjoyed under clause 6.2 and the exit regime would have been effectively neutered. Mr Costa had breached it in relation to the first phase up to the end of 2019. And after that, even though the obligation under clause 6.2 becomes more stringent, it's expressed in stronger terms after the end of the deadline, that deadline passed and there's been no compliance. Here we are, 5 years on, and yet Saxon Woods remains the shareholder of the company, a company in which there was an exit regime that should have been completed by the end of 2019.
Is the reason it wasn't pursued after about February 2020 because everyone agreed it would be a bad idea from then on? Am I overstating things? Given COVID.
Well, clearly the financial environment did change, but our position, Metric made an offer, continued to make expressions of interest into 2020. And if you forgive me, my lord, yes, if your lordship, it's certainly not the case that Saxon Woods has ever agreed or acquiesced in it not having been bought out under the exit process. Our position is that had that process been properly followed, there's every reason to believe that the exit would have been achieved by the end of 2019, and if not by then, within the first 2 or 3 months of 2020. That is to say, before the onset of COVID.
But do you say the obligation continues after COVID has passed?
Well, yes, the contract is still there, but the reality is it's the idea that the exit process is still alive is.
I'm not sort of interested about. Do you say the obligation is still alive? line, never mind the process.
Well, my lord, it's been breached and we're seeking to enforce our rights as a consequence of the breach. And the prejudice is certainly continuing as a result of the breach. But
is it a continuing breach?
The prejudice is continuing.
Oh, that wasn't the question.
No, I appreciate that, my lord. Under clause 6.2, once one gets past the end of 2019, there is an obligation to cause an exit. That has not happened. I think we would probably say that the time for that has now passed. That was an obligation that should have been, because it's a more stringent obligation, it should have been executed. And in a sense, the time, as I say, the time for proper compliance with that obligation has passed. I'll take you, it might be easier to make that point once we look at the clause, so I can develop that point. But certainly the prejudice, the point I'm seeking to make now is we're stuck in this company, a company from which we should have been bought out at the very latest in the early months of 2020. And yet nothing, we haven't got the, so whereas previously as shareholders, we had the protection of an exit regime under the agreement, which told us that we could be satisfied that we could get out, and if we couldn't get out, well, if there was, the only other alternative would be an alteration to the terms of the agreement, which would have required our consent. Whereas now, we in effect, we are left simply as shareholders. There's no effective exit process protection under the agreement anymore. What's actually happened, as I said before, is that our shareholding has been diluted to a negligible amount. And yet the company remains under the control of who we say, certainly the person who's been found to have deliberately caused this breach, and a person who we also say is in breach of his fiduciary duties, albeit that is our appeal, obviously. So we say, following Grace Biagioli, it is relevant when considering the overall situation, past, present and future, to take into account where we currently have ended up. And as I say, this was deliberate wrongdoing by Mr Costa. And he knew it was contrary to Saxon Woods' wishes. He flouted deliberately the exit process. He gambled on it. And in the consequence, we've remained locked into a company many, many years after we had agreed that the exit would have been achieved.
This is the bit I don't quite understand. The gamble is because it went wrong because COVID came along, I thought. So
yes,
that suggests that when COVID happened, the whole thing did change substantially. But you're saying it didn't, and actually, if it didn't, why couldn't you enforce the shareholders agreement in early 2020, or March or April 2020?
So, by way of an injunction or something of that nature. Well, we were at that point still hoping that an offer. So end of 2019, we were pressing for information about the exit process and pressing for Mr Costa to obtain a sale. We continued pressing for that into February, March, and then COVID happened. But by the early months of 2020, well, I think our point would be under 6.2, once you get past 2019, the obligation to cause an exit meant cause promptly. And so for them to have complied, they were in breach for having failed to complete an exit by, say, March. That the breach of the agreement at that point was complete. And so at that point we had a claim for unfair prejudice in principle. That would have been that would be the natural remedy for the breach of the shareholders agreement. I can't remember when the petition was actually presented. April 21. So these proceedings have been on for quite a long time. But I'll in terms of the wrongdoing, which is what is a relevant factor as far as Grayson Biagioli is concerned. One has to consider that Mr Costa, who remains in control of the company, has been found deliberately to have breached the agreement, knowing that it was contrary to our wishes, and moreover was in his personal interests. Secondly, that wrongdoing occurred over many months because he never got he just failed to properly pursue the exit process. And he is still in control of the company, and we remain as tiny minority shareholders now. And so we say that is relevant to the appropriate relief, and indeed meant that an unconditional buyout order was the correct answer. So that's ground 6, failure to look at the bigger picture, the broader ramifications for the petitioner in the situation they found themselves in due to the wrongdoing of Mr Costa. Then we move to ground 4, which is the other respect in which we say the judge went wrong in the exercise of his discretion in relation to the relief, and that he failed to give sufficient weight to the prejudice that had been suffered. So the prejudice comprised the
just the way you've put that, went wrong in the exercise of discretion, failing to give relevant weight. That's not normally the best way to start an appeal against the exercise of discretion. Just to say the judge gave too much weight to this, not enough weight to that. I mean, unless you're saying he went wrong in principle, just saying he gave a bit too much weight here and a little less weight there doesn't get you anywhere unless you say it's an order that no reasonable judge could have made.
So it's built on the errors of law that we've identified. The real point here is he failed to take into account material prejudice that, had it been taken into account, a reasonable...
Okay, so it's not just giving not enough weight, it's
a failure
to take account of a relevant factor.
Yes, my lord, I'm grateful. That is how I will put this part of the case. So this turns on the provisions of 6.2 and 6.3, which we say were disregarded, and that effectively undermined the entire process provided for under the agreement. So we know from the judge's findings that if the clauses had been complied with, there would have been at least one binding offer for the company by the end of 2019, and one or two, and possibly more, conditional offers. And those are reflected in the parameters in the schedule to his order. So that at the very least, it can be said that if the company had complied with its obligations in respect of exit, the shareholders, including Saxon Woods, would have had the opportunity to consider an offer. They were deprived of that. That, we say, in itself is prejudicial and was not taken into account. If things had been done properly, there is good reason to think that an offer that would have been acceptable to the shareholders would have been obtained. And again, we refer here to the expressions of interest made by Metric. So on 13th of September, their expression of interest was $110 million net of debt. They repeated that expression on the 19th of November, $110 million. Obviously a very substantial sum within the period of time. And then on the 23rd of January 2020, they actually increased the offer, the number, to $125 million. And Metric made those offers knowing that the company had failed to meet its targeted amount for EBITDA. And it was explicit about that. Metric said, we know we haven't made that offer. We know that budgeted number has been missed, but we still make this offer. Now, those numbers are obviously well above the 75 million threshold. Now, we say that to justify the making of a buyout order on the normal unconditional basis, it was enough that there was a realistic possibility that an offer would have led to an exit. And being deprived of that opportunity was materially prejudicial. So we don't say well, whilst we naturally do say that if things had been done properly, a sale, an exit would have been achieved, for the purposes of this appeal and establishing prejudice, we don't have to establish but for Mr Costa's breaches, an exit would have been achieved. We proceed on the basis that it's sufficient that the court can be satisfied that there was a realistic possibility that an exit would have been achieved, and we say the evidence is ample to demonstrate that was the case. It's not incumbent upon us to show on a but-for basis, for the purpose of prejudice, that we would have been there would have been a sale. We also say that approaching relief in terms of what would be fair and equitable, it's quite wrong to put the burden on the victim of the unfair prejudice, the wrongful conduct, to have to prove the counterfactual. It effectively requires the petitioner here to rewrite the history of the process that it was effectively cut out from, and which, as I've already said a couple of times already, involves moving parts, third parties and other variables. But on the basis of the current order, that is what we must do, otherwise, and prove that the best offer would have exceeded 75 million, otherwise we get no relief. Now, the premise, of course, for the decision to require us to prove that the 75 million threshold would have been exceeded was the judge's view that it was in the power of the shareholders to accept or reject an offer. And according to the judge's findings, which we'll come to, an amount of that offer or less would have been rejected. So that's why the judge adopts a but-for analysis. Unless we can show that the 75 million would have been beaten, he says there's no direct financial loss. Now, I've made the point that's an overly narrow approach to relief. I've made the point that it overlooks the fact that there was still the loss of the opportunity, which doesn't require a but-for analysis. There clearly was an opportunity. But the key point here is that the premise is incorrect. The but-for premise is incorrect. It's not correct that the shareholders had a free hand to reject an offer for exit. So I now need to take you to clause 6.2, which is at C, the core bundle, page 533. So what you have there, so at the bottom of page 533, we see the crucial clause 6.2. And we have investment period. And it says the company and each of the investors agree to work together in good faith towards an exit by no later than 31st December 2019, the investment period. In addition, the company and each of the investors agree to give good faith consideration to any opportunities for an exit during the course of the investment period. That's the basic obligation prior to, those are the basic obligations prior to the end of the year. So, I mean, even that is not a free hand to reject. The shareholders are obliged to act in good faith themselves, because it's binding on the investors and the shareholders and the company to work in good faith towards an exit. So, for example, unlike in the normal situation, a shareholder couldn't just capriciously choose to refuse to proceed with an offer. There is already some burden imposed upon them, some obligation imposed upon them to act in good faith towards getting an exit. So that is not a complete free hand. And of course, that's reinforced by the second part of the obligation about giving good faith consideration to opportunities for an exit. Again, it's more than just saying, well, it's up to the shareholders for whatever reason to decide whether or not they want to accept an offer.
Well, it depends what you mean by good faith. As you know, there's a bit of a debate about that.
Yes,
in
well,
in this sort of context.
Yes, my lord.
Been, for right, better or for worse.
So obviously, it requires them to be honest and not act in bad faith. And apart from that, it depends upon a construction of the agreement. And here, this is an agreement concerned with exit. And it's an agreement that was entered into in the context of an investment with a view to an exit, where for certain people it was very clearly the case that they were entering into the arrangement on the basis...
Is each shareholder required to subordinate their own interests to others?
Well, not necessarily. My lord, I mean,
you know where I'm going with this. You know, I mean, you stress the good faith. I mean,
yes.
It's there to add something one assumes, but query what? Is
Yes.
it anything beyond not to mislead, not to act dishonestly?
Well, yes, they have to work towards an exit. So, absent a good commercial reason, for example, in their own interest to think that a particular offer was not suitable, one would expect them to give it a positive view. So, I mean, in terms of subordinating their interests, that possibly goes too far. If they genuinely had a genuine commercial interest as to why a particular offer was not going to be acceptable or suitable for them, one can see that could be squared with a good faith.
Suppose somebody said, look, I don't want the exit to be before the 31st December 2019 because for that tax year, that'd be devastating for me. But if you could delay it until after the 31st December 2019, actually it's okay.
No, my lord, the deadline is fixed. They're stuck with the deadline because it says no later than the 31st, 2019. So they can't defer it into the other year just because it suits them. But in terms of how they treat particular offers that come along up to that period, they have to work in good faith towards getting out by the end of the year. And in my submission, that would require them to have some material, substantial commercial reason in their own interest to turn down an offer. If an offer looked reasonable and they had no particular axe to grind with it.
So let's take another one then, just so I understand the parameters of this. An offer could come in. Does it have to be a purely cash, or could it be cash and shares in some combination, which might suit some rather than others? I mean, they've got some latitude in that respect.
They do, and indeed, and this is a point that arises, I think, on the Learned Friends appeal. The fact is, a proposal would be made, which might have different moving parts, and if you were acting in good faith, you would engage with that proposal and seek to flesh out and flush out any issues that you might have with that proposal. Of course, what happened was, with Metric, they didn't even engage with it, so one didn't even get the point of moving it forward, which strongly illustrates the failure to act in good faith. But we've moved on to dealing with this as a matter of principle now, and my simple point is the judge approached on his but-for analysis. The basis of it was the premise that shareholders just had a free hand to reject an offer if they didn't fancy it, or indeed for any reason, even capriciously. And in fact, that overlooks a central component of this obligation, which is that you have to, everybody, the investors and the company, have to be acting in good faith towards getting an exit by the end of the year.
So what if the shareholders just thought, this one isn't enough, I want more than this?
They would have to have good reason for that. And in other words, one would say they couldn't just say, I fancy more money. There would have to be some genuine appraisal of why, objectively, the amount being offered was inadequate in the circumstances. So again, it's not just a free hand that one can unreasonably say, I want more. In the good faith, I mean, it's difficult to give it a comprehensive content, but certainly I would say it would not allow someone simply to say, I want more money.
So there may be a difference between an offer, say, in March and an offer in December. An offer comes in March and a shareholder says, I think we can do better if we wait a bit.
Yes.
Perfectly reasonable.
Yes.
And they still take that view in December.
Well, it becomes much harder for them to take that view. They are obliged to have an eye on the deadline under this agreement, and the fact that they are obliged to be acting in good faith towards hitting that deadline. So that the demand upon them to show that they are acting in good faith in rejecting an offer becomes more urgent, if you like, or difficult as you get nearer the deadline, if ostensibly the offer is, arguably reasonable.
Well, let's assume that you cannot, there's no time for a further offer, so this is the last chance before the deadline. Are you saying they have to accept that?
So what happens then, my lord, is that the directors, because they're the ones representing the company, would, if they're acting in good faith, put the best offer they've got to the shareholders, because that's the only chance they've got to hit the deadline.
But do the shareholders have an obligation to accept that offer, or can they still say decline because in their opinion it's not enough?
They do have an obligation, and this is why we get to 6.3.
So I'm not sure, actually, my Lord's question to you, I'm not sure you would answer it by going to 6.3. 6.3 certainly would apply, for example, if there'd been no offer before the end of 31st December 2019, and then you move into the exit process under 6.3. Or so you move into the exit process.
Well, my Lord, it's just
second part of 6.2 and 6.3.
Yes.
If there has been an offer capable of acceptance at a certain price prior to the 31st December 2019, are the investors obliged to take it?
If it's proposed.
Yeah, let's
So yes.
Somebody at the beginning of December says, we will complete by the 31st of December, binding offer.
So, Lord, 6.3 is not restricted to the investment period. That is to say, the first part of 6.2.
I see. Sorry, you're going to answer my Lord's question by reference to 6.3.
Yes.
Okay.
So we're still in the investment period.
Yeah, okay,
we haven't gone beyond the end of 2019. Lord Justice Zacaroli put it to me that if we get right to the end and there is at least a binding offer that has been put, which is can be put in some, has been put, which is not ludicrous. The directors, if they're acting in good faith, would be expected to put that to the investors because that's their only chance of hitting the deadline. And then you do get into 6.3, and you can see it obliges each of the investors to cooperate and assist. And Roman 2, procure, insofar as it lawfully can, that such exit is achieved in accordance with such proposal. So that applies during the investment period. And it's worth remembering as well that an exit didn't have to be a sale of shares, it could be a sale of the business. So this could be done without even having to strictly bother the shareholders. So if the board's acting in good faith towards achieving an exit by the end of the year, and the only option on the table is a sale of the business, well, the board should have pursued that. And that wouldn't have required the consent of the shareholders. So again, that thoroughly undermines the but-for premise that the judge was relying upon. Because the shareholders wouldn't even have a say in an exit of that nature.
If an exit is proposed in accordance with the terms, does that mean if an exit is proposed by the company?
Yes, I think that must mean if the directors put it forward.
Then the investors have obligations to assist
under 6.3
the company achieving the exit which it has proposed.
Quite. Yes, my lord.
Yeah.
Now, so we say that that's the position during 2000, up the investment period, up to the end of the year. If you get beyond the end of the year, it's a stringent obligation, I would suggest, because you look back at 6.2, and the obligation then is, third sentence, in the event that an exit has not occurred upon the expiry of the investment period, in addition to any rights provided by clause 3.5d in article 5, we don't have to worry about those. I don't think they impact upon the analysis. The board of directors shall engage an investment bank to cause an exit during, now everybody agrees that the words there during the investment period are a mistake. They shouldn't be there. At a valuation devised by such investment bank and on such terms as shall be consented to by the board of directors, which consent shall not be unreasonably withheld. Now, the judge had some criticisms about that mechanism, and possibly one can criticise that as how it was supposed to work with the investment bank. But what is absolutely clear is the intent of it. The intent of that is that if they haven't managed to hit the end of the year deadline, an exit has to happen. They've got to bring it about. They remove it, they bring in an investment bank to make it happen, and the directors can't fiddle around. If the investment bank come up with a sensible proposal, the directors have to accept it. And once that happens, under 6.3, the shareholders would have to go along with it as well. So this clause, these two clauses, and indeed I should mention while we're at it, 6.4, warranties upon exit. So if the shareholders have got, if it's a share sale and warranties have got to be given, the shareholders are obliged to cooperate. So
just going back a moment to my earlier question, if an offer came in March and the directors decided it was one that they would like to accept and they put it to the shareholders on your case would have to accept it.
Yes. So, my lord, it's worth remembering, of course, that the directors and the investors are somewhat symbiotically attached or related.
Yeah.
So the idea that there's going to be a particular mismatch between a director and his associated investor is not in reality going to happen. But it's true. If a good offer came in March and the directors thought this is a good offer, yes, and they put it to the members, the investors, the clause 6.3 is absolutely clear. There's no ambiguity about it. And what one would have to say is that if for some reason, notwithstanding that the directors had decided this was a great deal, the shareholders disagreed, well, they'd have to amend the agreement. And whilst we've got the agreement, we should go to clause 8.1. Just over on page 535, deals with amendment. Other than any amendments to clause 3.2a made by the board of directors in accordance with clause 3.2a, this agreement may be amended or modified, or any provision hereof may be waived, provided that such amendment, modification, or waiver is set forth in writing, executed by the company and the investors. So, amendment is explicitly catered for. After all, this was the second shareholders agreement. There had been one before, so the date had been changed once before. But
I thought what my lord was asking you, and maybe I misunderstood, but my lord was asking you does this effect require the parties to accept the first offer that's made?
no, it would have to be that if the directors propose the offer to the members, then yes. Well, they'd at least have to cooperate and seek to procure that it did.
Why do you get that? Do you suppose somebody made an that's right. So somebody makes an offer to the directors for the entire issued share capital of the company. That is undoubtedly an exit.
Yes.
And they do it in March 2019. What is it that says that there's some freedom for somebody to say no, given this clause?
Well, the directors could say no.
Why?
Well, because they're not bound by 6.3. That's the investors. So the directors are bound under 6.2, i.e. the company is bound. So the company, at that point, only has to give good faith consideration to an offer, which is the second sentence. They certainly have to do that, and they certainly have to have in mind the impending deadline at the end of the year, but they wouldn't have to then put the proposal to the investors. It's only once you get to that point that 6.3 is engaged. But in principle, if a good offer came, and bear in mind, this agreement had been in place since 2016. Under the previous agreement, there had been an exit provision. So exit has always been on the minds of these investors, and most particularly Saxon Woods. And so it wouldn't have been an oddity for an offer to have been sought and obtained in March. And if it was a good offer, it would have been open to the directors to say, excellent, why wait till the end of the year?
Or it might have been open to them to say, let's wait till the end of the year, but they have to give it good faith consideration, and those have to be proper.
They certainly would have to do that, my lord, yes.
A reasonable decision.
They must give good faith consideration, and that certainly didn't happen here. So these points were made at trial. They were not dealt with in the draft judgment. We wrote to the judge to try and get them addressed and taken into account. And they completely undermine the notion that underlies his conditional buyout order, that prejudice depended upon the shareholders having been prepared to accept an offer at a particular level. And the only way round this would have been for an amendment. So if we get to, as we did, we get over the deadline in end of December, and if at that point it's being said, well, there's only a very low offer available, well, by this point, we're into the second phase where, frankly, that doesn't matter because there's an obligation to cause an exit. And at that point, Mr. Loy, I would suggest, had the right to, if an offer had been procured, as it should have been by Mr. Costa, to hold the other investors' feet to the fire and say, well, we've got this offer. You see the obligations under 6.2 and 6.3. I'm going to force this to go through. And the only way around that would have been for an amendment to be made to the agreement, which would have required unanimous consent, and the consent of Mr. Loy. So his ability to withhold consent in that situation itself had value, which was completely ignored in the order that is made. So even if the offer would have been low, once you get beyond the end of the year, Mr. Loy, Saxon Woods still had valuable rights, because at that point he could say, we've got to go through with it, and you're obliged, exit's got to be caused, at which point he could potentially have extracted some value from that leverage, maybe an amendment to the terms of the agreement, who knows, but it was not nothing. It was a genuinely valuable leverage that he should have had if an offer, as it should have been, had been obtained in that period. And again, that he's deprived of that right. That was prejudicial, and it's completely overlooked if, in fact, we end up in a situation where, because of the conditional order, he ends up with no buyout. Now, I mentioned that we did go back to the judge on this front, and I should now take you to the paragraph in the judgment where the judge sought to deal with these points. And it's paragraph 262, which is at page 271. It's a very long paragraph, page 271. So the judge, you see, summarised the argument. So he says, even if it's been suggested to me that even if an offer below the level acceptable to shareholders had been received, the petitioner would nonetheless have suffered detriment. based on the provisions of clause 6.2 as they applied after the expiry of the investment period. And then he summarises those provisions. The shareholders are required to procure that such an exit is achieved in accordance with such proposal. What seems to have been argued is that if this process had been followed, i.e. if an investment bank had been mandated and had determined that the value of the company was below $75 million, had marketed it on that basis and had produced unconditional offers at that lower level, then the petitioner would have had a negotiating position. This argument in turn is based on the idea that neither the board nor the shareholders would have had any option but to accept such a lower offer, that the only way in which they could have escaped their predicament would have been by amending the SHA, that such an amendment would have required unanimity, and that the petitioner would at that point have been able to impose his will on them as regards the running of the company in exchange for consenting to that amendment. The basis of this argument is that the effect of the section is that the board is compelled to approve and the sellers to sell at any valuation which the appointed investment bank produces. I do not think this is correct for 3 reasons, and then we have his reasons. First, as was accepted by both experts, no investment bank would have accepted a mandate to in effect guarantee a sale of the company at a specific price. Now, as to that, we'd say this is criticising the mechanics of the clause. Clearly, a purposive interpretation of the clause would be available, and indeed the judge goes on to provide one possible approach, which you see a bit further below, where he says, in reality, the best that could be achieved would be that the investment bank would present one or more offers along with a recommendation. Well, fine. Now, the judge also criticises the argument on the basis that ultimately it would be a matter for the shareholders to decide whether to sell their shares. And that's at the bottom of the page.
I mean, is this right? You're saying that the bit of the paragraph in the bottom half of the page around the second hole punch and sort of is just missing the point, that what the instructions to an investment bank would have been there has to be an exit. Do the best you can. Yes,
cause an exit. It's now got to happen. We've missed the deadline.
And it wouldn't be a question of the bank saying, well, of course you're not going to guarantee us a sale. It's not the point. It's just there has to be an exit. Do the best you can.
Yes, because unfortunately the directors and shareholders between them have failed to sort it out by the end of the year.
Yeah.
And there's now got to be a mechanism that brings in a third party to cause an exit. And the directors have to accept what they come up with unless it's unreasonable. So it misses the point, my lord, absolutely.
Mr Davis, this is about the post-end of investment period, this paragraph.
My lord, yes.
That's what the judge is talking about. Does the judge talk about your submission that you've made to us about the relevance of 6.3 before or rather during the investment period?
Well, he mentions it if back over the page, about, I don't know, 8, 9 lines down in 262, where you'll see there he says the shareholders are required to procure that such an exit is achieved in accordance with such proposal. That is a reference to 6.3.
Yes, it is, but it's only in the context of what happens after the end of the investment.
Oh, forgive me, my lord. No, he doesn't.
No, I thought he did.
No, forgive me. But ultimately, where the judge ends up in this lengthy paragraph is to say, at the bottom line of page 272, I cannot see how the negotiating position hypothesised would have existed. If the shareholders did not want to sell their shares, they would simply not have sold their shares. But that completely overlooks clause 6.3. And he then goes on to say, this would have given the petitioner a right to bring an action. So this is in the situation where after the end of the year, a low offer has come in, and the hypothesis there is that Saxon Woods could have said, right, we've got to accept this, and the other investors may have been horrified, but the only way around that would have been for for everybody to agree to amend the Shareholders Agreement, which would have required the other shareholders to reach an accommodation with Mr Loy, which was a negotiating position that he had under the terms of the agreement. And the judge was dismissive about this, and we see that at the top of page 273. This would have given the petitioner a right to bring an action which is roughly coterminous with the action currently before me, that he was unfairly prejudiced by their non-compliance with the terms of the SHA. Since at that point it was already his position that he had been unfairly prejudiced, I cannot see how the accrual of a right to claim on this basis could have added anything to the position which he already had. So it's rather difficult to follow, I would suggest. It seems that the judge's reason for refusing to accept that Saxon Woods was prejudiced by being deprived of its contractual rights after the end of the year, specifically its right to withhold its consent to any variation of the contract, is that such conduct would itself have been unfairly prejudicial. So the fact that there would be more unfair prejudice seems to be the answer given to why it doesn't amount to unfair prejudice. So it's very difficult to follow and entirely unconvincing. The fact is that Saxon Woods was entitled to expect that steps would be taken in accordance with the second part of clause 6.2 to cause an exit after the end of year deadline passed, and that the directors would be obliged to put forward a proposal provided that it was not unreasonable, and then the shareholders would be obliged to proceed with it. And this post-2019 state of affairs is basically entirely overlooked by the judge in the formulation of his relief, specifically the conditionality around having to prove that 75 million would have been beaten in the offer, because that's premised on the notion that the shareholders would have had a free hand to reject the offer.
And just to pick up my Lord Justice Edis's point, I mean, one of the reasons the judge may not have dealt in his paragraph with the impact of clause 6.3 in the pre-year-end period is because you didn't address them, and your solicitor's letter didn't address that period. The solicitor's letter we saw earlier addressed what was called the second phase of the exit process, i.e. the period after the investment period had expired on the 31st of December 2019.
My Lord, you're quite right.
So the judge, to be fair to him, is responding directly to the letter that he was written.
Yes, these points were raised at trial. I should say.
But
no, it's true, of course there is a difference between the pre-end of year period and the post-end of year period, not least in terms of the obligations imposed on the directors. I mean, prior to the end of the year, the directors were obviously obliged to act in good faith towards achieving the exit, but they weren't obliged to put proposals until possibly we get, as my Lord Justice Zacaroli said, towards the end of the period, and it's looking rather desperate. At that point, you absolutely would expect them to put an offer. But of course, it changes after the end of the year, where the obligation is, the imperative to get on with it and achieve an exit is absolutely clear. So overall, we say the very unusual approach adopted by the judge of making the buyout order subject to a condition which would need to be satisfied at a further trial was unjustified and inappropriate. If it remains the case that Saxon Woods has to establish at this subsequent trial that an offer for more than 75 million would have been obtained, and it fails to meet that test, there will be no relief. It will have had no relief. A, for unfair prejudice, after all, the court has found unfair prejudice, but more substantively for the loss of all of these rights that it had under clauses 6.2 and 6.3, pursuant to which, emphatically, an exit should have been achieved and would have been achieved if things had been done properly. That was overlooked, not taken into account in the judge's discretion around relief, and that is, we say, why the decision was one that no reasonable judge should have reached. The fair and equitable remedy in all the circumstances was an unconditional buyout order.
So on that argument, the judge was wrong to place any conditionality on the basis of the shareholders might or not have approved it. That's
My lord,
not
yes.
relevant. But it does shift the focus back a stage earlier, which is the directors might not have proposed it. So does the same question arise there? In other words, there might have been offers received of whatever amounts before December, but the directors might not have put it to the
Well,
shareholders.
happily, the judge has helped us in that respect because he has found that there would have been at least one binding offer for an exit before the end of
Yes,
the year.
but that doesn't lead to the conclusion the directors would have put that offer wouldn't have proposed that offer.
Forgive me, my lord. That brings us back to your lordship's point earlier on, that if we're getting towards the end of the year and the directors are acting in good faith, knowing that the company has to work towards an exit by the end of the year, it must be right that they would have put that offer, they would have had to have put that offer to the meeting. And my lord, can I just, forgive me, and if they hadn't have done, we say clearly their obligations would have been to do so, but if they hadn't, the minute you get past midnight on the into 2020, that offer is there, and that would obviously have been the strongest possible start for your investment bank, having to actually go about and cause the exit, because at that point the directors cannot unreasonably refuse to put the offer.
Yeah, I was going to ask, you mentioned that there isn't really a difference between shareholders and directors. They reflect each other. But if it was right that the shareholders wouldn't have approved the offer because it was less than $75 million or pounds,
Dollars.
does it follow on the judge's reasoning that the directors wouldn't have proposed that offer because it's the same people?
Well, again, it depends on the timing, but if we're getting to December, we would say there comes a point where they would have to have proposed it.
I understand that, but is it the same practical question? If the shareholders wouldn't have approved it, the directors wouldn't have proposed it?
No. The directors are for the company, and they'd have to be acting to ensure the company complies with its obligations under the agreement. Now, I appreciate the investors have the same obligations, but they're different.
But that obligation is to the same one. It's to give good faith consideration to any opportunities for an exit. So if an offer is made to them, they've got to consider it in good faith. If they think it's not enough, or a majority of them think it's not enough,
I would suggest it's not for the directors to second guess the decision of the shareholders. I mean, the agreement treats them as different, the company and the investors as independent. And we've seen how Mr Costa dealt with the board. It's not as if there was a perfect flow of information. And in that context, it's important that the separate capacities of the different people involved is maintained, at least in the analysis. But ultimately, I mean, we did at trial put some focus on the first 2 or 3 months of 2020, because whatever the debate about what the directors may or should have done in the period up to the end of the year, that they should by then at least have procured some offers. And once you get beyond the end of the year, the more stringent obligations mean that those offers surely would have resulted in a sale. So I'm conscious of time. I wonder if I can just deal very quickly with ground 5 and possibly even more quickly with ground 7. Ground 5 is the factual point that we object to the $75 million. So this is if we're wrong on all of the arguments that I've been setting out as to the conditionality of the order. So we say there was no proper basis for the judge's finding that the shareholders would have rejected an offer that was 75 million or less. And the basis for that figure was raised, one of the points that was raised in the letter from Stevenson Harwood, because it wasn't, according to the letter, adequately explained in the draft judgment. And the final version of the judgment does contain an explanation, and it's paragraph 258. And so my reasons for setting it at this level are that first, Mr. Uberoy, in his email, which I've referred to in paragraph 72 above, clearly assumed that an offer at this level would have been unacceptable to the board. So it's based upon what the judge infers was an assumption made by Mr. Uberoy. And that email, if we go back to paragraph 72, this is in the context of some communications between Mr. Balfour and of Metric and the company. So Balfour of Metric sought to progress matters by sending an email to the board and shareholders attaching the Metric offer. 19th November, Mr. Uberoy proposed to Mr. Costa that they respond by explaining that although the offer is expressed to be for $110 million, based on the current numbers, Metric's approach would lead to a valuation of below 75 million. So that's as far as it goes. That's the sum total of the evidence that the judge relies upon for the 75 million figure. It's a comment by Mr. Uberoy as to how they might disparage Metric's offer by saying that if you apply Metric to the figures that they now knew, it would come in at that figure. Now, one can infer that he considers that's a low figure that might not have been acceptable, but he doesn't say that much. That is the sum total of the evidence. Now, it's just worth noting that the judge actually heavily criticised Mr. Uberoy's assessment that Metric's approach would have produced a figure of that kind. And we go to paragraph 80, which is over at page 198. We see it said that Mr. Uberoy seems to have been adamant throughout the meeting that the true value of the Metric bid was not the 110 million, which they had in fact offered. He seems to have come to this conclusion by assuming Metric would price their final offer exclusively by reference to the actually achieved EBITDA figure for the calendar year 2019. This is a bizarrely oversimplistic approach to have been applied by a person who held themselves out as a serious and sophisticated investment banker. So, as it goes, not only does the judge rely upon a somewhat oblique email as the basis for his 75 million figure, but he also criticises Mr. Uberoy's approach to the valuation. Now, it's also said that Mr. Loy, the other point I should say in fairness that the judge relies upon is that Mr. Loy is said to have accepted or did accept in cross-examination, and this is back in paragraph 258, that none of the shareholders would have been interested in the price of $72 million at that point in time. Now, what we say to that is that the fact that Mr. Loy gave that answer in cross-examination is not a satisfactory basis for concluding that if a binding offer in that amount had actually been made, it would not have found favour with the other shareholders. But there it goes. That's the entire evidence supporting the 75 million figure as the threshold. And really, the bigger point here is that there's no proper evidential basis for adopting any alternative figure. That's the real point. So the judge's attempt to, on the one hand, find there's been unfair prejudice, but on the other hand, given his concern to ensure that it had to be based upon financial loss to impose this condition on his buyout order, he had to find a figure. But the problem is that wasn't an issue at the trial. Neither side relied upon a particular figure being a benchmark for whether or not there would have been a buyout. On our case, prejudice did not depend upon us having to establish on a but-for basis that an offer would have been made at a particular value, which would have been accepted by all the shareholders. Our case on prejudice was broader than that, as I've said. As for Mr. Costa, he did not run a causation defence based on the best offer obtainable being a particular figure, be it 75 million, 100 million, or whatever. So there was no orderly inquiry at the trial into what particular figure would have been acceptable to all of the shareholders. It's fair to say, questions around that topic were asked and a variety of answers were given, but it was not an issue that was explored in an orderly way at trial. So the judge's approach, which depended upon identifying this threshold figure, was unexpected. And it required him to come up with a number, even though the issue had not been properly canvassed at trial. So
does that conclude ground 5?
there's one final point, my lord, which is that what we further say, what makes this worse, is that if Mr Costa had wanted to argue that it would not have been possible to obtain an offer that was acceptable to the shareholders, this should have been part of his defence, and he would have faced the burden. And there's no reasonable basis to conclude that Mr Costa discharged that burden. He didn't argue the point. He didn't argue that a particular figure needed to have been hit in order for the sale to have proceeded. So the problems of the lack of evidential basis for the 75 million figure, we say, really just reinforce the point that the whole approach of trying to make this a but-for quasi-damages kind of relief was misconceived. Now, that does, my lord, complete ground 5. There's one other ground, which is the ground on costs. Now, I don't necessarily think I need to address you on that. You have our submissions in the skeleton. The long and short of it is we say that if we succeed here and get an unconditional order, naturally we should have the costs of the first instance liability trial.
Usually we look at what costs orders ought to have been made and ought now to be made in the light of whatever the outcome of the appeal is, wouldn't we?
Yes, and so if we ended up with an unconditional order, we would say we should have got the costs as well. We also say that in fact we should have got the costs anyway, and indeed there are grounds for indemnity costs in respect of the case of dishonesty, which was, we say, abused at the trial. But I don't want to waste further. We've overrun, and I'm conscious there's a great deal to do tomorrow. So. Your Lordships have our submissions in writing. I can return to it if necessary when I get my next go.
Yes. Thank you, Mr Davis. Thank you very much indeed. Thank you. So, Lord Wolfson, I think the agreement is that everybody will have the same time, so you have the whole of tomorrow without any difficulty.
Well, my Lord, yes. It may be, of course, that we might, so to speak, take a different view of how we allocate our time subject to my Lord's questions, and maybe we go slightly shorter on our first go and slightly longer, but overall it's equal time, my Lord.
Indeed so. So, yes, well, we have 2 days left.
My Lord, yes. And I think both counsel are confident, all counsel are confident that we will certainly complete well within the 3 days, I'm sure.
Thank you very much.
All right.
So 10:30 tomorrow.
I'm grateful.